Hello, everybody. Welcome to this week's Facebook Live session Q&A. I'm Paul Holcroft, and I'm going to be running through HR, health and safety issues that are going on. And as we do every week, please feel free to just pop a question into the comments section. I'll answer the questions as we go through the session. And just a bit of information to go through at the beginning. Got some updates of things that have changed over this week as well. I'll run through them at the beginning. I'll run through some questions that we didn't get time to answer last week, which I'll pool together into a set of answers that people were looking for. And then we'll move into, like we usually do, into an open Q&A session. And just feel free to ask as many questions as you want, to pop a comment into there. Now, what we've seen over the last 5 weeks or so since we've been doing these sessions is we've had a lot of contact from businesses who have said to us, the sessions are great, the sessions are really good, but can you give me a bit more help? Is there something more you can do for me? We see the problems, we see what you're talking about in these sessions, but can you help me with this? And we can do this as well. So what I've got here is I've got a phone number for people who want a bit more information. It's 0800 046 3179. And there's a web address as well, which is croner.co.uk/FB Live. So if you want any more information from us, you've got any more questions you want to pop in, just pop them in there and we'll pin this comment on as well so people can see it. So what I'm going to run through first, as I usually do, is I'm going to run through the updates that have happened since last week. Now, we're still waiting for the information from the Chancellor, which I'll definitely have for next Wednesday's session, which is going to outline exactly how the part-time and flexible new extension to the furlough process is going to work from August. So we'll have loads of that for next week, but there's been some really good information and some really good updates that I'm going to run through this week. And the first one is that we've got an update to the Treasury direction. So what businesses had before was looking at the law that surrounded furlough, surrounded the job retention scheme, was we had the government guidance. So we had what was published on the direct.gov website, government guidance, and we also had the Treasury direction. Now, the Treasury direction is derived from the Coronavirus Act, so it's essentially a piece of law. And the people who were on the first sessions will remember, and I think I've spoke about this quite a bit in the other sessions, is that if you have a point where the government guidance on the website and the Treasury direction contradict each other in any areas, then the Treasury direction will win because that's a piece of law. And what I've been through in the past is I've been through some areas where it's contradicted it for areas that are really, really important to businesses, really important to employers, to employees. And there has been a contradiction in that guidance before. Well, what we've got in the update now is, in the update, we've got a bit of clarification on some of these really important points. So I'm just going to run through. I've got 3 really important points that have been clarified in this new direction that I want to run through. The first one, which was the one, I think this is the most significant change. This is the requirements that you have when you're placing an employee on furlough. Now, how it used to work was that in the Treasury direction, it meant that you could place an employee on furlough, and it was how you communicated it with them, was that you had to confirm that in writing, which could be electronic. So essentially just the employer, just the business, you have to have the agreement with the employee, but you confirm that agreement in writing to the employee. Now, the Treasury direction previously asked us to go one step further. That asked us to also get a response back in writing from the employee. So there's a contradiction between the two there. That's been clarified, and it's gone to what the government guidance is. So as this reads now, is that the agreement is made in writing or confirmed in writing by the employer, which mirrors the government guidance, such confirmation being electronic form, such as email. So it takes away that requirement from us to have to get that response back in writing. I think we knew from the HMRC that would have been okay, but it's nice that we've got that point clarified now about how we furloughed employees before. Second point on there, which I thought was really important, relates to statutory sick pay. Well, a lot of questions that I'm getting on here are about, okay, I've got an employee who's on sick. Can I put that employee on furlough? And coming back from furlough, returning to work as well, what state do they go into? Again, this was a contradiction before, that before you could have an employee who was on a period of sickness absence and move them over to a period of furlough, as long as you did that for business reasons, that was fine. You could do that before, and that was what the government guidance said. But the Treasury direction said that the period of SSP that they were on had to end. So think about, for that, best example of that is an employee who's shielding. Employee who's been told by their GP they need to shield for 12 weeks. Well, under the government guidance, at any point in that 12 weeks, we can agree with that employee to move them off a period of sickness absence and move them onto furlough. And we can then start to claim back under the job retention scheme. They start to get 80% pay or 100% pay, whatever's been agreed with them. But the Treasury direction, remember this being a piece of law, contradicted that. That said this needs to wait for that period to end. Now, this has been updated now. This has been updated to say that, in caveat to that, provided that the time of the end of the period of incapacity to work is determined by an agreement between the employer and employee, which means now that we don't, as we had to before, decide between the two. That it means that if we've got someone who's on a period of SSP, that we can move them over to furlough with the agreement of the employee. Because what you can't do for that is you can't claim SSP and you can't claim under the job retention scheme for the same period. So you can't overlap. You can claim SSP for some of it and then move it over to the job retention scheme, but you can't claim double under the scheme. So that's something which is really nice, really glad that that one's been clarified. And the last one that I thought was relevant comes in about what a director can do. Now, I've had this question asked quite a bit about, I run the business, I'm a director of the business, and I myself am furloughed as well. I'm an employee as well, and I'm furloughed. What can I do? Because the Treasury direction, government guidance is uniform on this. It's very clear that you can't work, cannot undertake any work. So what is an exemption to that category? So we've got another couple of categories here which have been added in. So when I've been asked this question before, what can a director do? The only thing that it let us do before was fulfilling a duty or other obligation arising by or under an act of Parliament relating to the filing of company accounts or provision of other information relating to an administrator. So just two things really. One, filing your accounts. Two, if you're giving information to an administrator in your company's in administration. They were the only two things we could do before. That's been extended now, and it's added in a couple more that a director can do whilst on a period of furlough. One, I think this one's helpful, is making a claim under the coronavirus job retention scheme in respect of an employee of the director's company. You need somebody to facilitate the scheme, you need somebody to make those claims. It's nice that it's been clarified now that making one of those claims is not going to jeopardise the director themselves' position and whether or not they will be furloughed. And the second point is making a payment of salary or wages of an employee of the director's company. So we can pay wages to the employees, we can make a claim under the job retention scheme, we can file company accounts, and we can provide information to administrators. That's it. Those are the four which are exempt from being classified as work. So hope that helps. That's nice that we've got that extra bit of guidance, a bit of clarity there. And what's good is that it's paired up the government guidance and the Treasury direction, because that was a concern for us advising that you've got two contradictory instruments there, which is nice that we've got a uniform view on some of the really key points. Another thing that I wanted to go through, which has been a really big update, has been the announcement from the PM about the opening of shops. So what's opening? What's opening from the 1st of June, which is this Monday. So as of this Monday, outdoor markets and car showrooms are going to be open. That's what's going to be open Monday. And what I'm going to go through when I'm thinking about all of this as well is, yes, it's going to be open, and yes, the next thing is non-essential retail, but yes, it's going to be open. But what businesses need to be thinking about now, and what we're speaking to clients about regularly now, is it takes a bit of time to get this in order. It takes a bit of time to get this right. We need to be undertaking risk assessments. The business, we need to be looking at the 5-point plan, which has been set out from the government about how to make the workplace COVID secure. And we need to be making sure that everything that needs to be done to ensure that our employees are returning safe is done. And I'm sure I'm going to get quite a few questions today about what do I do with this employee who says this? What do I do with this employee who says this? What are our rights when it comes to this? All orientated around, a lot of the questions are about getting people back to work now. That's where businesses are at that we're speaking to. They're not talking about putting people on furlough anymore. They're talking about, how do I get them back? I've got demand, my orders are up, I want to get back to working, but I need to make sure my employees are protected, and I need to know my rights when it comes to certain things that they're saying and certain things they don't want to do. Before all of that, you need to make sure that the health and safety of that business is in order. Risk assessments are done. You make sure that we're compliant. You make sure that every risk that should be there for an employee, and we're covered to make sure all social distancing where that can't be done, that we're reducing that risk as much as possible, and that we're covering every area that's been set out in the government guidance. So that's a caveat to kind of the reopening of shops and how that's going to work. So we've got 1st of June, Monday, outdoor markets, car showrooms. Then from 2 weeks on Monday, which is the 15th of June, all other non-essential retail. This is, Prime Minister said, from department stores to independent shops to reopen. This doesn't include, but there's certain categories this doesn't include though. So doesn't include restaurants, nightclubs, bars, pubs, bingo, casinos, betting shops, hairdressers, beauty parlours, things like that, so on and so forth. So there's a list of things it doesn't include. They're not in that non-essential retail category, but some will be opening. And the government have issued some guidance on this. It's 33 pages long. If anyone's got time to read that guidance, 33 pages long, that's what our teams are looking through here. But this gives you an outline of how to fully understand what your responsibilities are when it comes to the health and safety side of getting your business back. But also the other area that we need to consider from a HR perspective is about the shift patterns of individuals, that what businesses are not looking to do and what's going to be coming in with the new furlough guidance and the part-time furlough working that's going to be coming in from August is there's going to be staggered shift patterns. There's going to be different days of work, different hours of work for employees as well. And we need to make sure that we've dealt with that from a HR perspective, because while the job retention scheme is great for keeping employees engaged and keeping them employed, and meaning that it's not going to make mass redundancies across the country, that it doesn't supersede employment law as it was before. Employment law still sits there as it was before. There's just a new scheme. There's a new term furlough and there's a new scheme that's come into place. So that's something we need to think about. But when you're looking at the 5 stages that need to be done, you've got the risk assessment. This is from a health and safety perspective. Number 1, you've got your risk assessment to do. Number 2 is cleaning, hand washing and hygiene procedures are updated. Reasonable steps taken for employees to work from home. Reasonable steps taken to maintain a 2-metre distance, and where 2 metres can't be maintained, managing the transmission risk. But all of those, as you can understand, are bespoke, they're complex, they're unique to each business as well. So that was another thing I thought was of interest, that the shops are going to be opening. And another area, which was something that we've been giving quite a bit of advice on recently, so I thought it'd be something that was worth mentioning and worth just alerting people to as well, was thinking about returning to a building which hasn't been occupied for a certain amount of weeks or months, and the things that a business needs to do in that circumstance. So not just about thinking, okay, I need to get my building ready for social distancing and reducing the transmission risk of COVID. That's one thing. Another thing is about, how do I get my employees back? How do I make sure that the employees are engaged? How do I make sure that we're not breaching anybody's contract? How do I return people from furlough? These are all complicated questions. Changes to shift patterns, changes to days of work. But what about a building itself that hasn't been touched in weeks, months? And there's a few things that, from speaking to our health and safety experts here, I thought were really good for me to highlight today. Number 1, fire alarm systems. So these are usually tested every single week. These might not have been tested for 8 to 10 weeks. This is going to form part of the risk assessment. And the last thing that I wanted to go through was just making sure that first aiders were done, that the updated requirements for first aiders were there. You need to think about how many people you've got as first aiders within your business, and you've got the appropriate levels of people there as well. And the other thing that we had was just some FAQs which were asked at the last session. I kind of pulled these together to 5 questions, and these were questions which were coming up. And as I said before, we've been so oversubscribed with the amount of questions and the things that I can get round to in these sessions. And what I'm trying to do is, for the things that we missed and I couldn't get around to from the last time, trying to pool them together and deal with all of those questions at the beginning of each session so I can get round to things. So first question that we had last time, the 5, was how do we extend furlough? We sent out a letter which said it was until the end of May, could be reviewed at any time. So what you need to think about with furlough is that furlough is something which is agreed between the employer and the employee, and that at any time the agreement can be removed from either party. But I don't think in practicality that's going to be too much of an issue. So what I would make sure that you do in that circumstance is, the key to it, first of all, is the letter. What letter's been issued? Here we're at version 9 of the letter because, as I said, the government guidance is changing constantly and the position with the Treasury direction is changing constantly. We're making sure that our documentation is kept up to date to tie in with that. So it depends on what's written in the letter. But what I think is best practice to do is keep in regular contact with your employees to make sure that you're speaking to them regularly, to make sure that you're updating them on what's happening, and they're not working, but you're keeping them up to date with what's happening and how the business is progressing. And then if you want to be in a position where you say, okay, we're going to extend the furlough, then I would speak to them about that and talk about how that's going to look like. But I think you'll be okay to, as we said, the Treasury directions change, just confirm to them in writing. And email's fine. Confirm to them in an email, we've discussed this, we've agreed this, and this is the position as it's going to be. That's as long as the rate of pay on that stays the same. And I would put that in there as well, that's what's been agreed with them as well. And that depends upon how your letter's worded and what's in that letter. But nice that we got the clarification from the Treasury direction about how that can be done now. Next question is, can a staff member be disciplined for failing to follow the government guidance outside of work? Now, I think this is a really interesting question. If you've got an individual who is taking outside of work and is meeting up with multiple people who they shouldn't be meeting up with and increasing their chances of catching the virus and breaching the government guidelines on this, can you say internally, I can discipline that person, I can bring them in and discipline them? It's a wider question that we've been getting asked for years, is can I discipline my employees for things they do outside of work? I remember when I was in court and I ran a case about an employee who'd proven to have taken cocaine at the weekend at work. And the question was whether or not we could discipline that individual under the current rules we had on the disciplinary process. And that is dependent on what's written within the contract, what's agreed within the contract. And further from that, and there's case law on this, and what's related to work. Can you discipline somebody for something they do at the weekend? Well, in theory, if you've got the right clauses and the right way of doing this, then yes. If you've got something within your contract, which for that case mentioned a drug test and a certain amount of an illegal substance within a certain amount of blood, then at any point if they're tested within work, then they can do that. But we don't control what an employee would necessarily do at a weekend. So it's a similar principle to think about COVID and how they disregard the risks of COVID and how they breach government guidance as well. It depends upon what's within your contract. If you wanted something like that to reach over that far, you would think about having something in the contract which talks about their breaches, talks about how that relates to work, but it's something which would be bespoke to your contract, to your agreements. And also you want to be cautious of how much control you're exercising over an individual and whether that would warrant pay for that period as well. But depends what's in the agreement, depends what's in there, and that's all contract related and what's dependent between their employees. So the third question was, is it okay if we claim furlough for an employee while allocating some of their job to a non-furloughed employee? Short answer is absolutely yes, it is. So for an employee to be placed on furlough, the employee needs to be not working. They need to be not working, the employee who you're claiming under the job retention scheme for. The rest of your employees can work. Just the person you claim under the job retention scheme for. So 1, they're not working. 2, it's for a minimum period of 3 weeks. And 3, it's as a result of coronavirus. So here, and this is what we're seeing quite commonly, is that yes, there might be a diminution of work in the business, but it doesn't mean that everybody goes on to furlough. But the people who aren't on furlough do tend to take a little bit of other people's jobs, and they might be doing 60% of their own job and 40% of other people's jobs, which they're covering. We don't need those people in because somebody can cover that work. So that's quite common that the work would be covered by another individual. But the key that you need to remember is the people who you're claiming under the job retention scheme for, that they're not working. That's the key. They're not working in any way. Okay. So no one's giving them a call to say, can you just talk me through how I do this? Or I'm a bit confused about how I get into this system and do that. And can you talk me through this? That would be risking providing a service which is under the definition as work as well. So that'd be something that'd be a risk if you did that as well. So fourth question we had is, what if an employee will not agree to a reduction from 100% pay down to 80% pay? What if somebody won't agree to that reduction? This is a question that we're getting asked quite a bit. We've had people who thought, okay, when the original job retention scheme came in, when we originally could furlough people, that we would do that for a period of time, and at that period of time we would be happy to pay it 100%. And at first that was 3 months. So we thought, okay, great, we're going to pay that for 3 months, and we're going to pay it for March, we're going to pay it for April, and we're going to pay it for May. And businesses budgeted for that. They wanted to do what they saw as the right thing, and they wanted to pay 100% pay. That's the approach that a lot of businesses took. Now, what do we do if we're in a position where we want to take that down to 80% pay and we think, well, we can no longer do this? So 2 things you need to consider here is, number one is, and if anyone wrote a question before, or if you popped a comment in the comment bar, if you could just pop that in again. I had a little connection issue where I popped off for a second and popped back on, and it's just wiped off my questions. So if anyone who's got a question, if they can just pop it back in there, I'm nearly at the end of these FAQs and I'll jump straight to those questions now. That'd be great. So even if you can see it on your own screen, Just be great if you could pop it in there for me again so I can get a chance to answer that. So what if you want to take an employee down from 100% pay down to 80% pay? Well, two things, okay? So number one is we need to agree with the employees that they're on a period of furlough. We've already agreed that with the employees, and as I said before in answer to the first question, it depends what the terms of that agreement were, for what period it was for as well. If we've agreed it for a certain period, just need to get agreement to do it for another period, which I don't think should be any issue. But then what you want to think about is, what about the pay? So as I said before, the job retention scheme and furlough does not supersede employment law, doesn't wipe employment law aside. Employment law still sits there behind all of this, and what sits there is an unlawful deduction from wages, a breach of contract. If you've got an employee who is earning 100% of their salary in their normal role, and then you pay them 80% of their salary just on a normal day, they would come to your office and say, that's unacceptable. They would say that's a breach of contract, an unlawful deduction from wages, and a fundamental breach of contract, and say, I want to claim constructive unfair dismissal if they resigned off the back of that breach. So serious stuff, ordinary unfair dismissal claims, serious stuff. It's no different now. And this is something that employers need to be wary of. This is no different. If you're going to reduce your employee's salary from 100% to 80%, as with anything in contract law, you can do that if both parties agree, but you don't go below a statutory minimum. So you can't agree for them to have less than 5.6 weeks annual leave in a year, for example, because that's the minimum the law tells us that we're allowed to have. But for salary, we can agree to take that down to 80%, and national minimum wage rules don't apply to this payment as well. So just bear that in mind, to the furlough payment. They don't bear that in mind. So what you would do with that employee, is my advice, would be I would contact them, I would explain the situation to them, I would explain that I need their agreement for this, and this is my rationale behind doing it. I need to take you down to 80% pay. The business can no longer afford for this to happen for the period. We want to keep you furloughed. We want to maximise what we can do under the job retention scheme. We've got 5 more months left of this job retention scheme. We want to maximise what we can get for that, for you to make sure your job's secure. We can't continue with your 100% pay. See if you can obtain the employee's agreement for that. If you can obtain their agreement, fantastic. Confirm it in writing to them. We agreed this. This is what we agreed, and you're going to stay on a period of furlough. That's it, done. Okay, great. Keep in contact with them, keep updating them, but that's that side of it done. Now, if they disagree, it leaves you in a different position. If they disagree, they're going to take 80% pay, then you need to look at what other options you've got. So simply as a business, if they don't agree to 80% pay, whether you've got work or not, this depends on what your contract says. If you've got the ability to take somebody's hours down, you can do that. But for this purpose, we'll talk about a full-time contract. So if you've got fixed hours and you haven't got work for that individual, you still need to pay them their full salary under their contract. To not do that, you would need to look at another option. You would need to look at a redundancy situation. And that would be something you would say to them, well, if we can't agree to this, I need to look at other options that I've got. And that other option in this situation would be redundancy. So that's why I don't think there'll be too much of a problem with getting this agreed with employees, if that's something that as businesses you can't do and you can't support that payment anymore. But as with anything, the best thing to do is approach them, have a conversation with them, explain why this is happening, but always remember that don't just make the change, because that would be a breach of contract and an unlawful deduction from wages. Obtain their agreement that you both agree that we're going to reduce your salary down to this amount for this period of time while you're on furlough. Let's get that agreement in writing. Then we know that we're nice and secure, we're nice and safe if that ever comes back up again. And the last question that I had, which flowed over from last week, was around pile-on, so paying employees in lieu of their notice pay. So what this means is, if I've got an employee who's got 3 months notice, rather than them work the 3 months and them get paid as they would usually get paid on those 3 paydays over those 3 months, I just pay them day one, 3 months worth of pay in one go, or I pay it over 3 months, but I pay usually one go. I pay them in lieu and they never come back again. They don't work again. And this is an option which is sometimes taken in certain industries, in certain departments where they don't want interactions with clients over that period of time. And that's the thing that, or some businesses like that as a clean break and like that's something to do. The question is, can I make a claim for pay in lieu of notice under the job retention scheme? My answer to that in short would be no, that wouldn't be my advice. And I'll explain how that works. So can you claim notice pay under the job retention scheme? There's nothing that says that you can't. So yes, if that employee satisfies the test under that period, they are furloughed, they're not working, they satisfy the 3 stages, then yes, you can claim under the job retention scheme for that individual. We don't see any issue with that, and nothing from the guidance or the direction which says contrary to that. But pile-on will be different. because for pylon, you would essentially be claiming for a period that the employee was not employed. The day that they're pylon, the last day in the business, is their effective date of termination. That's the last day they work for you. And what you will be doing would you be claiming for another 3 months after that date. They don't work for you for those 3 months. Yes, you've made a payment, but you don't know what's going to happen. If they would have worked those 3 months, something different might have happened. They might have come back to work. They might have gone sick. Something different might have happened in that period. We don't know that. So that's why I would advise, no, I would not make a claim if someone was claiming back for pylon. But if it was just normal notice pay just being served over a 3-month period, I think that would be okay. So those are the questions that we had from last week. And if I can just say to people, just pop your questions in the comments section on the side there. Great, I've got a few more that have filled back up. And I'll just get around to these now. I'll move through these questions now. Okay, so first question I've got is from Hina. Can we include our furloughed staff with non-furloughed staff who are able to work from home in a team meeting and discuss and communicate our risk assessments to reopen the workplace? Can we discuss this with our furloughed staff, and can we ask their feedback, which we might need to take into account when we're bringing them back into the workplace? This is a fantastic question. What a brilliant point. The thing you need to think about with people who are, a simple question is people who aren't furloughed, who are working for you, absolutely fine. Have the conversation with them. They could work, they can do everything they would have done before because they're not relevant to the coronavirus job retention scheme. But for the ones who are on furlough, who are having a claim made, the thing that we spoke about in a few other sessions is about the risk of a team meeting. Now, employees, while they're on furlough, are allowed to undertake training. Government's clear on that. Just a little subtle part to that is that attracts national minimum wage payments if you've got someone right at the bottom of their earnings. But yet, training is absolutely fine. The two things they're not allowed to do is they're not allowed to generate revenue for your business, and they're not allowed to provide services for your business. They're the two things that would be by definition work, and anyone who's working cannot be claimed for under the job retention scheme. So we're doing risk assessments. Fantastic, this needs to be done. We're doing the risk assessments in our building, and we want to discuss this with the individuals who work there, which is exactly what we should be doing, is discussing this with individuals and making sure that everyone who's there has got some input on it, is happy with returning back to work and feels safe with that way in which they're returning back to work as well. So communicating those measures with them about returning to work and asking for their feedback. This is something that it's all going to be dependent on what exactly is discussed in that meeting, on what exactly is discussed. And by definition, is someone giving you information about your business and how this should be done, providing a service? That's the question. There's no clear guidance yet on whether or not someone who's giving a comment on a risk assessment is someone who would or wouldn't be providing work. My opinion I think you would be quite safe in calling up your employees and talking to them. And this is what businesses should be doing, is calling them up, is talking to them about, this is what we're doing in the building, this is what we're doing to get the building back safe, this is what we're doing to make sure that the building is secure for when you get back. It's the question of their input. It's them inputting and giving you information and providing you with guidance, providing you with their expert knowledge, which you might think about it, might pay somebody else for and might use somebody else's guidance for. Is that not in essence providing a service? So that's one that there's no clear guidance on that, but if you did ask for a lot of input from those employees and they gave, depends on what they said and how much input they gave back and how much they interacted with the team, would that run the risk? Would that run the risk of being as far as providing service? So next question from Jody is, can you furlough someone who is getting paid statutory maternity pay? So short answer to this question is yes, if you get agreement with the employee. The thing they can't do is they can't claim for statutory maternity pay and you can't claim under the job retention scheme at the same time. You can claim it for the same period of maternity, so they might have however many months on maternity pay, and then the next day they move over and they move on to furlough, then you claim for them under the job retention scheme, but you can't go back and make that job retention claim for a period when they weren't furloughed before then. And what you'd want to do in that situation is you'd want to speak to the individual. They would return back from maternity leave. You would speak to the individual, would get their agreement, and they would move on to a period of furlough. Now, sounds like a good option, but what you need to think about there is with a period of maternity leave, once that period's ended, it's ended. You can't go back onto maternity leave again for the same period that you were on before. So if you've got an individual who comes back from maternity leave and they think, great, I'm moving over to furlough, and then a few weeks later the business changes, or their maternity leave would have ended before the end of the job retention scheme, and they're in a position then where I would have still been on maternity leave. I was planning to take a full year to be off with my child, and I'm planning to still be on maternity leave. Then they can't go back onto a period of maternity leave then, and you need to deal with that with the options that you've got there as a business. So that's just a part of it to consider as well. Another question is, have you got any advice on bringing employees back on staggered shifts? We've never had to stagger shifts before, thank you. This is something that I was talking about this morning with the team. Do a briefing in the morning with the team, and this is something that I was talking about that's coming up with a lot of businesses. A lot of businesses use an Excel spreadsheet. They use the wall planner that goes on the wall to write up who's in on what day, and people go in and have a look at who's in there. Just simply now, that's not going to be suitable. It's a lot more complicated than this now. And something that we have within a business is a product called Bright HR. That's something which has rotas in there. It has the ability to send push notifications to people's mobile phones. This is great because what this does is it allows us to put in a complicated shift pattern, and you might have to stagger start times because the guidance says think about this in the risk assessments. Also, think about public transport and people having staggered start times. So some people start at 8, half 8, 9, half 9, 10, and then they start to go out the office at 2, 2:30, 3, 3:30, and you stagger those shift times and stagger days. Complicated stuff. You might have to do this on alternate days. You might have to change this at short notice as well. And what you need to think about with this is this also requires a HR side of it. So you can't just say, okay, I'm going to change everybody's shift patterns, because I work for you and I've got a contract, and that contract says that I work from 10 a.m. to 4 p.m. Monday, Tuesday and Wednesday. That works great for me because I've got children and I need the other days off, and that's why I took this job. So you don't want me to work that though, because that doesn't tie into how your business is staggering shift patterns. So you stagger all the shift patterns, so you get your employees aware of them, you want to do that, but what do you do from a HR perspective? Well, you need to agree with me as your employee that you're going to change my shift patterns. If you don't do that, you're breaching my contract of employment. Unless you have the right to vary shift patterns in your contract, and you have a clause which allows you to do that, you need to negotiate that with me. You need to agree that with me, and talk to me about those days that you're going to do that on. So that requires agreement. Get that confirmation in writing, but also think for that about what platform you're using to do this, because there might be a point in time as well in the future, you might get audited by the HSE, you might have somebody coming in and looking at how you did this, and you want to be able to evidence quite clearly with a nice time-stamped note to say that this is what I did with shift patterns, this is how I did it, we made all the employees aware of it, and this is how I set it out for the business. And here's a nice printout of my shift pattern to make sure everybody was safe and they weren't overlapping. And this is something that we're doing with a lot of our clients at the moment as well. So yes, a lot of employees have never had to stagger shifts before. My advice to everybody watching, some businesses, this might not relate to, but pretty much everyone is you need to get ready for this. Come August, and they're going to announce the new job retention scheme rules the end of this week. Come August, everybody's going to be thinking about different shift patterns, different days of work, staggered start times, all that stuff is going to have to be considered. You're going to have a system which is going to be able to handle all of this and make sure this is nice and clear, and be able to communicate it with the employees, and be able to evidence that you've done it, and also go through the HR exercise of agreeing this with them as well, and getting that agreement confirmed and making sure that you're not falling foul of any breach of contract and a breach of contract claim, constructive dismissal claims as well, all of the things that are going to come out of this, and pair that with the full health and safety audit that needs to be done of every business. And this is going to be complicated stuff for a lot of businesses when they get back, to make sure this is done right. This is all brand new, but just to make sure this is done right when they get back. Helen, this is kind of a bit on from one of the FAQs that I got asked. Actually, this is a good point. Ties into this well. Is for those people still working and covering others' roles, which before I said was fine, that they may not have done before. Do we have to change any part of the contract? That's a really good question. So you've got an employee who has a contract of employment. Contract of employment rarely has the roles and responsibilities in there. That's usually in a job description that comes with the contracts as well. Something that was there forming part of the terms and conditions, something at the beginning of the employment which sets out what the role was. But we all know that these roles evolve over time and people's duties change over time as well. And as with that, as I would say with anything else, just to keep yourself nice and safe, I would offer them that this is what we're going to do, and just get their agreement that they're okay with it on a temporary basis, covering that. And then if anybody raised it as an issue, I would deal with that on a case-by-case basis. If anyone raised an issue to say that I don't want to do these other duties, I don't feel comfortable doing them. And a lot of employees can feel stressed by having to do other duties they've not done before. They don't understand it. They've had a very straightforward linear role before, and that's something that it was a good conversation with them and talk them through that. I wouldn't say that I would amend their contract of employment, but I would get their agreement and just get a nice paper trail of their agreement to say that they were happy with the new way of working on a short time basis of how that was going to work. Okay, a question here from Lisa. So we work in the theatre industry. This is funny because I was speaking to a client who works in the theatre industry this week about classification of self-employed contractors, workers, employees, what status they fell under as well. That was something that I was going through this week. Industry has been hit quite hard for us and may take some time to get back to normal. Are we able to reduce staff hours and pro rata salaries in alternative to redundancy? Would this be an amendment to their contract if they agree? This is something that is not going to be unique to the theatre industry. This is going to be something which is going to be a question which is raised by a lot of businesses. A lot of businesses have been coming through this. Yes, the job retention scheme was brilliant. It saved a lot of jobs and it gave businesses the ability to fund those payments for a period of time. But a lot of businesses that we're still speaking to now are still thinking about redundancies. How long is it going to take us to recover from where we're at? Is this going to mean that we're going to have to reduce headcount slightly within businesses? The job retention scheme is geared towards not only helping us in, but as we get back to work. Now, that's the reason why there's 5 months left of it, is it's supposed to phase and help us back out as these businesses recover to avoid redundancies. So they're planning on people still being on furlough within a few months. 5 months we've got left of this, and businesses will have recovered substantially before that period. So what the government are thinking is that hopefully we won't have to think about making those redundancies because it will have recovered to that point. But unfortunately, that's not going to be the case for every business. And I think almost all businesses at the moment are considering their headcount, they're considering the contingency plan, they're considering what they need to do if they're in this situation. So, question is, are we able to reduce staff hours and pro rata salaries as an alternative to redundancy? Yes, you can do that, but that is an alternative to redundancy. So what would need to happen there would be that you would have a redundancy situation first. So you'd have a rationale for redundancy. Don't want to go into the complexes of redundancy too much, but a diminution in work. Exactly what's happening with the coronavirus situation fits into that. The level of work required has reduced within that business. The roles have had their amount of work required for them reduced. That's something that we've got at the moment, and there'll be a lot of businesses across the country with redundancy situations at the moment. It's then what we do in that redundancy situation. We go through a consultation with employees, and one of the outcomes of that is dismissal by reason of redundancy. It's one of the 5 fair reasons for dismissal. So dismissal by reason of redundancy, obviously compliant with all usual employment law and unfair dismissal rules and redundancy rules, but parking that for a second, what you always look at in those situations is an alternative to redundancy and try and agree an alternative to redundancy with the workforce, a pragmatic approach to this. So rather than we've got 20 people here and I need to lose 10% of people. So 2 people out of the 20 are being made redundant and 18 of you are going to keep your jobs. Sometimes what happens in that, because we just don't have the work, sometimes what happens is everybody agrees to a 10% salary reduction, and a 10% reduction in the hours that they work. And that's an alternative to redundancy. So I get the cost saving that I need as a business, and the employees, everybody keeps their jobs, but on 10% less pay and 10% less hours, rather than 2 people within that pool losing their jobs. And that's an alternative to redundancy. That's something that you consider as part of that process. That's through a process, and that's an alternative to redundancy. You would agree that with the employees as well, and go through that process with them and just keep them fully aware of what happens. Would it be an amendment to the contract? Yes, they would have new terms and conditions after that process, which would have the lower hours, which would have the lower salary in there, which they would agree to. That would be an offer and acceptance of these lower packages, which they would agree to. Might want to be for a certain period of time as well. You might say, let's do this for 6 months, and then we'll go back into another consultation again. It might be that we do this indefinitely, and then I'll review that when I feel comfortable to do that in the future, when the business can do that. Because, and especially in your industry, want to think about that we don't really have any clear, right, here's the date. This is the date that we're going to be up and running and going back as well. So in simple terms, yes, you can think about that. But the other caveat that I always talk about in these sessions as well is just remember when you're thinking about alternatives to redundancy, We always had a few alternatives to redundancy before, but we've got a brand new one now that we never had before, which is furlough. And how a tribunal is going to see that after this period of time is something that we're not yet sure. That would it be reasonable for an employer to take the option of dismissal by reason of redundancy when they had an alternative available, which was just to leave the employee on furlough under the job retention scheme? How reasonable that's going to be, we don't know yet, but that is a brand new option that was never considered by the tribunals before. Okay, Alina, what happens with annual leave for employees on a fixed term contract? So annual leave, first of all, for anyone who isn't aware of how this works. So while an employee is on a period of furlough, they continue to accrue annual leave. So annual leave still accrues while they're on a period of furlough. And then you have the other question of, can an employee take annual leave while they're on a period of furlough? Yes. And nothing that says an employee can't take a period of annual leave while they're on furlough. And then the final point on that, which we're getting asked a lot every week, is can I require my employees to take a period of annual leave while they're on furlough? Because what we need to think about here as business owners is what's going to happen if we come back end of October. Okay, and we're back at the end of October. We think, great, we're back into work. We've got November, we've got December, we've got 2 months left, and almost all of my employees that are returning have got 5.6 weeks holiday left, and they've not taken yet, and they want to come back to when I need them most, just before Christmas, and everyone wants to go back off again, or we want to phase people back and they want to take holidays. And what we're getting asked a lot by clients now is, can I say, I need you to take some holiday now. I need you to take some holiday while you're on this period of furlough. Yes, you're off. Yes, you're getting this rest and relaxation, but I need you to take some leave on this period. We require you to take that leave. Now, we can ask employees to do that. They can make a leave request. We can accept that. That's fine. But if they don't want to do that, can we essentially require them to do that? And as it stands at the moment, there's nothing that says we can't. And we're advising our clients that they can go ahead and require people to take leave. The rules on this under the working time regulations are that as long as you give the employee double the notice of the leave that they're going to take. So if they're going to have 1 week off, we'd give them 2 weeks notice they're going to have a week off. Essentially takes 3 weeks for an employee to be required to take a week's leave, that we would do that in advance. And we would say to them, now let's do that. And a lot of firms now are thinking about hitting a certain percentage. You don't want an employee to exhaust all the leave, because in theory we could do that, which I think will be retrospectively corrected. But as it stands now, I think a good thing to do would be to think that as of now, we're 5 months in, that if you've got a calendar year that you'd want someone to have taken 5/12 by this point, and next month, by the end of next month, they've taken half of their leave by that point, and if they haven't taken it, we ask them to take it, or we require them to take it by that period. And that's what a lot of firms are doing at the moment. Your question is specific, though, to annual leave for employees on a fixed-term contract. So employees on a fixed-term contract still accrue annual leave for that period. If they're on a fixed-term contract for 1 year, it depends when that fixed-term contract expires. If the fixed-term contract expires, they would no longer be employed. If that fixed term came to an end and we didn't have a contractual agreement for them to go into another term, but yes, they would accrue that. And if that ended, they would be paid all annual leave accrued but untaken at the end of that period that they would have accrued over the time they were on that fixed term contract. Depends on the wording of the contract, but that's a simple principle of how that works. I hope that helps. Okay, Lisa, another question. Can we allocate, so just a point on from holidays, so I think I'll deal with this one now. Can we allocate different holidays to staff on furlough and staff still working? Yes, you can do that. There's no restriction on allocation of holidays to any employee. Obviously, first thing to do, I think best practice is to ask them to take some holidays when they'd like to take them. But if not, yes, we can allocate them holidays. As I said, double the period of the holiday is the notice we need to give for them. Or would this be seen as unfair? Some staff have more accrued holidays than others. So that's the question you've got, is a question of the employees saying, well, I don't feel it's right that this has happened. I don't feel it's right that a colleague of mine before March had taken 2 weeks off. I'd taken nothing, but you want us both to have got to a point where we've taken a certain amount of leave by a certain date. This depends upon your own decision as a business about what you want to do with that. I don't think it would be reasonable to take everybody to the same portion for the same time, because that's the easiest way to deal with it as a business. The fact that somebody's taken that leave beforehand, it doesn't mean that they get any more leave, because the person who's furloughed has been off for that whole period. I don't think they've been subject to anything that's detrimental to them. They've been off and resting the same as somebody would have been doing who's on leave, and they still have the same amount of leave to take within a year. So as long as we took them up to the same entitlement, I think that would be fine. So question from Soraya here. Can staff return on reduced hours and still be furloughed on their remaining contracted hours? So 2 answers to this question. As it currently stands now under the current rules, absolutely not. No, they can't. If an employee works 1 hour at the moment, they're not furloughed. They can't be claimed for under the job retention scheme. So they can't work at all. And they need to do that not working for a minimum period of 3 weeks to be able to claim. And it's not in blocks of 3 weeks, as I've been asked before. It can be 4 weeks, it can be 5 weeks, 6, 7 weeks, that's fine. But no, as it stands now, no, they cannot work. This is what's coming in August. This is what, by the time I do the session next week, I'll have all of this out for you. I'll be able to outline everything and how all of this works about somebody who is going to work on part-time hours, they're going to work reduced hours, and they can still be on essentially it's going to be, we're thinking it's going to be like part-time furlough. So we'd pay, say they work 50% of their hours, we would pay as a business 50% of their wages, and the government would pay 30%. So they'd still get 80, but we'd be paying half and getting half of that. And that's phasing the employees back to the workforce. I think that is the best option and the way to do it, because if you've got a business with 10 employees and you only need 5 of those employees back because that's all the work you've got 5 employees who are at home who aren't getting exposed to the workplace, who have been reduced in the amount of training that they've got as well, and 5 employees who are in who might not want to be in compared to the people who are off. What would work much better is you can have all 10 in, but all working half of the time, and you as a business can still claim the same fee that you could claim under the job retention scheme as you can claim now. So, Soraya, in answer to your question, no, we can't do that at the moment, but in August, that's something that we should know about. But next week, I'll be able to tell you exactly how that's going to work. Okay, so a question from Helen. Do staff that are furloughed have a requirement to keep in touch with their employees? And if you decide to get them back but unable to get hold of them both by phone or email, where do you stand as an employer? So do staff and furlough have a requirement to keep in touch with their employees? So if the question is, do staff have a requirement to keep in touch with their employer, then I would say no, they wouldn't. That is a requirement for a business to keep in touch with their staff while they're on furlough. There isn't a requirement to do that, but we would always advise that was best practice to do that, to make sure that we kept in touch with those individuals, to make sure that we just kept them abreast of what was happening within that business as well. But the other part of that is, if you decide to get them back and able to get hold of them, they should be available. You should have a means of contacting them. It shouldn't be that they're not available for a period of time, because at any time you can remove them from furlough. So you should have obtained personal email address, personal mobile for them as well, just to make sure that we know exactly what's going on. But as an employer, no, they're still employed by you. They should still be available to work as and when you need them to work at reasonable notice. And if they're not, I would be increasing the level and the tone of the communication I was using with them. Depending on what your contract says, this could move forward to it being a disciplinary issue if the contract covered it that much, but that would depend on what the terms said. So okay, so Sally, this is a really interesting question and something we're getting asked quite a bit as well. So this is, I have a member of staff who's vulnerable and I want to bring back to work. We've worked our way through the 5-point government plan and have not reached agreement. Can I legally leave her on furlough as I can for those who are shielding? So if you've got an employee and they're vulnerable and you have the option then of leaving them on furlough, you just agree with them that they're going to be on a period of furlough. So we're fine to leave an employee on a period of furlough. I'd be thinking a little bit more about why you couldn't get agreement with what's happened with the health and safety risk assessment and why this employee is saying the workplace is not secure. And one thing that businesses need to be thinking about now is that there's been a £14 million investment from the government into the HSE to allow them to investigate businesses who aren't doing this right, who aren't doing this properly. And that's why it's key more than ever now that we make sure that we get this right as businesses. That'd be something that I'd be concerned about why that hasn't been agreed. But yes, you can leave them on furlough, as you can do for someone who's shielding. You just need to gain the agreement for the employee about that and think about the 80% pay as well. Okay, Sean, this is a follow-on from this question. We've got staff here who need to bring some of them back from furlough. However, one's refused to come back because he feels it's not safe. We've had quite a bit of this. Who feels it's not safe, and another one who's they're saying they're not a vulnerable person, wants us to guarantee. And what they're saying is, we don't feel like the risk assessment which has been completed by you is adequate for my level of security for me returning to work. And this is something that we're seeing quite a bit now, is people challenging these risk assessments, challenging. This is why it's so key, and this is why I said this at the beginning of the session, is that this is number one on the list to make sure that you've got risk assessments done, you've got a professional in to help you with this, that this has been completed properly, and you know that if this is tested by the HSE, you know that if someone does come in and look at this, because what we're going to have is we're going to have disclosures raised by employees. They can go directly to the HSE. They're encouraged to do this in the guidance. And the HSE have had increased funding to be able to investigate this. So the thing we need to do as businesses is make sure that we've got this right, make sure that we've got our business right, make sure that we've got our risk assessments right, and we've followed this plan. Then you've got options, though, if this employee says, I am not going to return to work, and the government has been vague on what the rights are of a business in that situation. Because as we look at it, then if the employee isn't on furlough, yes, you can agree for them to stay on a period of furlough. We can agree for the employee to be on furlough for a longer period of time. But for a lot of businesses, that is not the solution that they're looking for, because they need people back into work. So if that's not the solution that they're looking for, what other options do they have? And you could have an option with an employee, as you would normally do at any time in the absence of the job retention scheme, is to agree a period of unpaid leave with an employee, to say to them that, yes, it's absolutely fine for you to say that you don't feel safe to come into work and you don't want to come in. We have complied with what we need to do. We're happy with our risk assessment. We've had professional help with this. We're happy that this is up to the required standard that it needs to be. So we're happy with it coming to work. But if you feel that you're unsafe to do so, we can agree for you to be at home, but we can agree a period of unpaid leave. They would still accrue annual leave while on that period, but we would agree for them to be on a period of unpaid leave. That's something we could look at as well. We could look at a stricter option of saying that this is a reasonable management instruction to have you in work. So we're going to take you down a disciplinary route for doing that. What you need to bear in mind with this is that option attracts a substantial amount of risk. And also bearing in mind the fact that somebody raising an issue with the quality of the health and safety assessment that's been done in the workplace will be seen to be a protected disclosure, which gives them a certain amount of protection from a detriment, from a dismissal, anything like that. And they would say that being taken to a disciplinary and what comes out of that could be a detriment due to them raising that issue. This really is going to be a difficult situation for a lot of employers that they're going through, and one that at the moment, this is number one on the list, that we need to make sure that we've got this risk assessment right, that we've done everything properly, we've had professional help, we've made sure that we've done this right. So when these situations do come up, and the situations do arise where you've got problems with individuals, you know that if anything does come and get reviewed or anything does get tested, that we've done everything we need to do, and make sure that's all right, all set up. So if I just take one more question. Okay, Katie, I'm sure this is a question that a lot of people have been thinking about. Childcare is a massive issue with staff. Where do we stand? The issue we've got at the moment is that a lot of businesses have reopened, a lot of industries have reopened. The rules on people coming into the office has relaxed. So those have changed. So we've got people coming back into work, but at the same time, schools haven't opened yet. Some of the schools are starting to open over the next week or so, but schools haven't opened properly yet. So people are saying, well, great, I understand you want me back, but I've got childcare. Childcare is a huge issue at the moment. Once the schools come back, I think we'll be in a much better position over the next 2-4 weeks. I think we'll be in a much better position. But as it stands now, you've got an employee who's saying, I can't come in because I've got childcare. Now, you've got the option to leave them on furlough. You can leave them on furlough, but you might need that individual back. And I think the advice that I've been giving around this, the best thing I think to do is to have a conversation is to have a conversation with that person and say, this is the situation. Is there any kind of middle ground we can find? Can you do a couple of days? Can you do reduced hours? Is there anything we can do to get you back in some sort of capacity and you can work childcare around that arrangement? Is that something we could consider doing? So that's the situation that you're in with childcare. I would advise against saying it's a reasonable management instruction for you to come into work. You've not come in and I'm going to take you down a disciplinary route, because that would attract a substantial amount of risk. But at the moment, yes, we can still furlough those individuals, and you do have other options you consider to agree with them as well. So that's everything that we've got for today. For next week, we'll definitely have the guidance from the Chancellor about how the new changes are going to come back with the shorter working, with August, with how all of that's going to work. But as I said before, there's been a lot of people who've wanted to contact us after this to say, this sounds really interesting, there's a lot I need to do. Can you give me a bit more help with this? Can you give me a bit more advice? So we've got a phone number for this. This is 0800 046 3179, and the web page to go on to get a bit more information. If you've got any more questions or want any more information on there, that is croner, croner.co.uk/FB live. So that's everything for this week. When I get on next week, we'll have a really good update, but hope everybody has enjoyed the session today, and thank you for all the questions. Anything we didn't get around to, I'll get next week and we'll pick up those questions as well. Thank you. Bye.